The trustee.
Sir, you
Now,
need to stop. You're being in contempt of court. You need to stop, or I'll have the officer assist you in stopping. All right,
that's
Missy,
false
I
imprisonment.
want you to stop talking, or you can go upstairs to the county jail. Now, do you want to go to jail tonight? The
Your
second
Honor, I
right.
also have a right to understand the nature
Sir.
of this. I have a right to understand the
All
nature
right.
of
If you don't want to listen to me, you can go to jail.
I'm not
That's
being
why an
disruptive. I'm
attorney
just
can
trying to
help.
understand the nature and cause of the
All right,
charge.
officers, I'm gonna close
What am I
it.
doing? I'm sitting here trying to understand the charge.
If he gives any more grief,
Your Honor, can I please go home? Your Honor, can I please go home? I'll leave.
All right, everyone. Today we're looking at one of the most difficult sovereign citizen cases we've featured on this channel. This individual is in court for speeding and not having valid insurance, yet he's treating the entire situation like it's not serious at all. Despite facing the possibility of real consequences, he acts as if the courtroom is just another place to argue instead of a setting where the law is enforced. What really stands out is how casually he talks to the judge, almost like they're having a friendly debate rather than a legal proceeding. This isn't an informal conversation, it's a courtroom, and the stakes are very real. His confidence seems misplaced, especially given the potential outcomes he's facing. I'm curious what you all think. Is this a lack of understanding, poor judgment, or something else entirely? And do you think the judge handled the situation professionally under the circumstances? Be prepared, because this individual relies heavily on confusing language and circular arguments. With that said, let's jump in and see how this hearing unfolds.
Mr. Johnson appearing in person and pro se. Your name tag on your uniform says Johnson, so I presume you are Mr. Johnson. Now, sir, if you could get right in front of that microphone, thank you.
Can you hear me?
I can. Sir,
Yes.
you're charged in count one with speeding 82 miles per hour in a 65 mile per hour zone. That is a traffic infraction. It is not a charge that carries any jail time. It has a scheduled fine. 82 and a 65 is $87, but then there's also 108 court costs. In count two, you're accused of operating your motor vehicle without proof of insurance. Now, if you had insurance but just couldn't find it, you can get the proof to the county attorney and she'll probably dismiss that charge. If, in fact, it had lapsed or something was happening so that you didn't have insurance on the vehicle at the time being January 4th, 2024, that is a B misdemeanor. The maximum penalties as far as jail time would be 6 months, although probation is usually granted. There is a mandatory minimum fine the court must impose of $300, but it could be as high as $1,000. You do have the right to hire any attorney of your choice. If you cannot afford an attorney, you can apply and see if you qualify for court appointed. You can waive your right to counsel and represent yourself. Another option, you might be able to apply for diversion. That is where you apply, and if the county attorney approves you for diversion, you would pay agreed upon fines, costs, get your insurance current, and pay a diversion fee, and she'd dismiss the charges and keep them off your record. If you want to talk about diversion or anything else with your attorney, you certainly will have the opportunity to do that. Your pleas, you have a choice of pleas. You can plead not guilty and we can set this for trial at a later date. You can plead guilty, admitting the charge, and we would proceed with sentencing. Or you could plead no contest, which is neither admitting nor denying the charges, but you'd still most likely be found guilty and we'd proceed to sentencing. If you want to look into diversion, we'll enter a not guilty plea to give you time to do that. You can always change your plea, but once you're convicted, pre-trial diversion is off the table. So
probably not eligible for diversion based on his driving record.
Oh, okay. Well, do you want to talk to an attorney then and discuss whether or not you have a defense? Or?
No, Your Honor, I would like to request a declaratory judgment due to there is no agreement for my performance under any agreement or commission of this court.
Well, I don't need an agreement from you, sir. So if I were...
Well, Your Honor, I simply do not understand the nature and cause of the accusation with regard to the jurisdiction of the venue and nature of this action until the prosecutor properly alleges them there. I cannot enter a plea to the charge until I have the opportunity to raise a meaningful defense on my behalf.
You can already feel the tension building with Joe Webster. You can practically see her patience wearing thin in real time. This sovereign citizen genuinely believes that tossing together a stream of buzzwords about freedom and jurisdiction is going to get him out of trouble, but that's not how the law works. The rules here are actually very straightforward. If you're driving without valid insurance or a proper license, you're breaking the law. No amount of improvised legal language or misunderstood concepts is going to change that reality. The court isn't confused by these arguments, even if the person making them is convinced they've found a loophole. What really stands out is how confident some people are in ideas that clearly don't hold up in court. It makes you wonder where these beliefs come from and how they spread so widely. Whether it's online forums, videos, or word of mouth, these arguments keep showing up, and they keep failing the same way. And just when you think it can't get more intense, things start to escalate. His tone shifts, emotions rise, and the interaction with the judge becomes more confrontational. Let's jump back in and see how the court responds when lines start getting crossed.
All right, I will then, since you cannot enter a plea today, I will enter a not guilty plea for you and give you
I
time.
object, Your Honor. I object to you entering a plea to me because I must understand the nature and cause of these accusations. So I do not agree to you entering a plea on my behalf.
Well, your position is taken and I'm still going to do it. I will note your objection for the record, but I'm going to enter a not guilty plea.
Well, I object to you entering a plea on my behalf.
Your objection is noted, and if the time comes, you can appeal that to the Court of Appeals. Now, on the issue
Well,
of the attorney.
Your Honor, I would like to ask, who bring these charges against me? I should have the right to question.
All right, we're not going to have this debate right now. I've told you your charges. I've told you the state of Kansas has filed those through its attorney, Jill Gillette. Now,
Well, I would like to call the state to the. I would like to call the state to the stand, Your Honor.
We're not doing
the
that,
state bringing charges against me. Who's it? How did I injure the state?
All right, this is your first appearance. I advise you of your rights. I advise you of your charges and possible.
Your Honor, I object to the proceeding, for I do not know the nature and cause of the
I'm
proceeding.
entering a not guilty plea. Missy, when is
I object to you entering I object to you entering a plea on my behalf. I do not grant you that right.
Missy?
The court
You're supposed to act as a trustee.
Sir, you need to stop. You're being in contempt of court. You need to stop or I'll have the officer assist you in stopping. Missy?
Well, Your Honor, I would like to also bring to you
September
according to USC 12203.
Deputy Miles.
And also Article 3, the judge must operate in good faith and good behavior. So therefore, if you're making a threat towards me, then
Deputy,
that's
if he's going to
urging
keep
me to
being
perform in your
contentious, I'm going to
court.
have you take him into custody on contempt.
Then that would be illegal search and seizures, Your
No,
Honor.
it wouldn't. You need to go back.
It will.
All right,
It's
Missy.
false
I
imprisonment.
want you to stop talking or you can go upstairs to the county jail. Now, do you want to go to jail tonight?
Your Honor, again, Title
Deputy
4,
Miles, could you
let's
come in and
see.
assist the defendant?
September 27th at 9 o'clock will be the court date.
September 27th, you said 9 o'clock?
Yes.
9 a.m. You must be back here, sir, in person at the courthouse, or you will be arrested for failure to
Your
come to
proceeding,
court.
Your Honor.
Now, that deputy there is going to take you into custody if you cannot control yourself through the remainder of this hearing.
I'm not doing anything. I'm just enforcing my right, Your Honor.
All right, so your first right is to have a hearing date, and that is September 27th, 9 a.m. The
Your
second
Honor, I
right,
also have a right to understand the nature
Sir.
of this.
This guy really cannot take a hint. The judge has been more than patient, and credit to Judge Webster for maintaining her composure, because not everyone could sit through this without losing focus. It's clear she's making a real effort to keep the hearing professional and controlled, even as the situation keeps dragging on. Now, when this sovereign citizen says he has the right to know the nature of the charges, he's not technically wrong. That right is a core part of due process under the Sixth Amendment. The problem is, the judge has already explained the charges multiple times, clearly and on the record. He simply isn't listening. Instead, he acts as if the court is running some secret or unfair proceeding, which isn't the case at all. At this point, it's no longer about understanding the law, it's about refusing to accept it. When someone is this resistant, even a straightforward explanation starts to feel like a personal attack to them. The real question now is how much patience the court is willing to extend before drawing a firm line. We're about to find out just how far Judge Webster is prepared to go to keep order and move this case forward.
I have a right to understand the
all
nature
right.
of the cause.
If you don't want to listen to me, you can go to jail. Do you want to hire an attorney or apply for court appointed?
No, I do not. I don't need to hire an attorney, Your Honor.
You want to represent yourself?
I don't need to hire an attorney. I would like for you as the judge, Your Honor, to explain to me the nature and cause of the...
All right, I'm not going to appoint an attorney if you don't want me to. If you want, you said you don't want to hire an attorney. If you want to apply for court appointed, the officers have forms there that you can fill out. If
I
you
just
don't
want to
fill them
understand the
out,
nature
I'm
and
going-
cause.
If you don't want to fill one out, I'm going to assume you don't want an attorney. And then if you come to court September 27th at 9 a.m., you're going to be representing yourself if you don't hire or apply for court appointed. And so you've got the third issue, does he have a bond? Looks like you do because you failed to appear February 27th at your first appearance. So bench warrant was issued, bond was set at $1,000 cash for professional surety. Looks like that was posted. Looks like you made a cash bond of $1,000. Does that sound right? You put up $1,000 cash back in July 12th?
I'm still trying to understand the nature and cause of this allegation, Your Honor.
I will continue your bond unless you get yourself hauled into jail on contempt before you leave. I will continue your bond with the condition that you reappear here in person at September 27th at 9 a.m. So you've got your court date, you've got your bond, and we've talked about your lawyer. Now, you're wearing a U.S. Army uniform with the name Johnson on it. Are you in or have you been in the United States military?
Your Honor, I'm still trying to understand the nature and cause of the allegation, Your Honor.
All right. If you can leave the courthouse now without any further disruption, I will let you do so. But I'm going to have those officers escort you to make sure you do so. So, Ms. Gillette, anything further?
Your Honor, it is your oath to explain the nature and cause of the allegation against me. Are you failing to do that?
All right. You can either walk out the front door with the officers, or you can walk upstairs to the county jail with the officers.
Let me know in the comments. Do you think this ends with him spending the night in jail, or does he finally stop talking and leave like the judge repeatedly asked? At this point, it honestly could go either way. He still has a clear choice in front of him, which makes this situation even more frustrating to watch. The judge has given him multiple warnings, patiently explaining what he needs to do to move things along. She's practically urging him to cooperate, but instead, he keeps clinging to his prepared script like it's going to somehow change the outcome. It won't. Courts respond to compliance, not repetition. What makes this even more puzzling is learning that he previously served in the Army. That background makes his resistance to authority here even harder to understand, given how structured and rule-based the military is. At this point, it's less about legal arguments and more about whether he's willing to listen and follow simple instructions. The situation is reaching a tipping point, so let's jump back in and see how it plays out.
The choice is yours. Either leave
Your Honor, I'm trying to
or
understand.
leave disruptively.
I'm not
That's
being
why an
disruptive. I'm
attorney
just
can
trying to
help.
understand the nature and cause of the
All right,
charges.
officers, I'm gonna close
What
it.
am I doing? I'm sitting here trying to understand the charges.
If he gives any more grief,
All I'm asking is to understand the charges. This
I
is for
told
the
you the
record. You said it's for the
charges.
record, so I'm trying to understand what am I being
told you
charged?
the charges. Goodbye, sir.
I just want to understand the nature and cause of the charges, Your Honor. That's all I ask. It is your
I've
oath
gone
to
over
give
those
that.
with you. If you tell me what kind of questions you have, I'll be happy to answer them, but I've already told you.
Okay. Under what jurisdiction is these charges being brought to me under?
The state of Kansas has charged you with speeding 82 and a 65 and operating in a motor vehicle without liability insurance on January 4th, 2024 in Greenwood County, Kansas. You failed to appear for your first appearance and a bench warrant was issued and you were arrested and you made a bond of $1,000 cash or surety, posting a cash bond. Now you have to go to court and you have to answer those charges. You can
Your Honor, I
have
know.
a trial if you like, and the burden will be on the state of Kansas to either prove or disprove. If they can't prove it beyond a reasonable doubt, you're let go.
Well, I'm still trying to understand what jurisdiction am I being charged under, Your Honor? That's all I'm trying to understand.
You're being charged under the jurisdiction of the state of Kansas under its criminal law.
But according to the Constitution, there are only two
All right,
jurisdictions.
we'll have that on a later date. We'll be at recess, officers. Please escort him one way or the other, depending on his behavior.
But I'm still not understanding what you're charging me with.
Goodbye. We are adjourned.
But if she's the judge, I'm supposed to have clear and concise of what I'm being charged with.
The judge just said it. You give us any problems with it.
I'm not giving y'all a problem. I'm trying to.
Put you in handcuffs.
Well, I'm waiting on the Your Honor to explain.
All right, Missy. We'll
But
be-
that's it.
That's our last case on the docket, isn't it?
This is not good.
Yes.
All right. All right. Ms. Gillette, I'll see you at 3:30 docket.
Your Honor, can I please go home? Your Honor, can I please go home? I'll leave.
All right. Well,
Can I go home?
I left it up to them and I left it up to you and then they were to behave accordingly.
This has to be one of the strangest court cases I've seen in a long time. Watching it unfold, it almost felt like he was pushing things in the worst possible direction. The judge went out of her way to explain the charges and the court's jurisdiction in the simplest terms imaginable, breaking everything down step by step. Still, none of it seemed to register. What stood out was the combination of confidence and complete misunderstanding. The judge explained the law clearly, calmly, and repeatedly, yet he either couldn't or wouldn't engage with what was being said. At that point, it stopped being about confusion and started looking like refusal. That brings up the bigger issue here. Sovereign citizen cases consume an enormous amount of court resources. Judges, clerks, prosecutors, and court staff all end up spending time managing arguments that go nowhere, while legitimate cases wait in line. Taxpayers ultimately pay for these delays. Also, someone can argue theories that have already been rejected countless times. Despite all that, the judge handled the situation professionally. She gave him multiple opportunities to comply, explained the law patiently, and only drew a firm line when it became clear nothing was changing. That balance between due process and courtroom control isn't easy, and she managed it well. So what do you think about this case? Was the court too patient, or did the judge handle it exactly right? Let me know your thoughts in the comments. If you enjoyed the breakdown, don't forget to like and subscribe. It really helps support the channel. Thanks so much for watching, and take care everyone.